Today I'm talking about gender balance on corporate boards, which is a topic dear to my heart, and you probably know that yesterday was International Women's Day, so hopefully you were thinking about that, and we may be a day late, but I hope the effect of that hasn't worn off yet. But basically what I'm talking about here is the directive that was agreed last year, Directive 2381. So what I'm going to talk about is it's a very sort of practical approach to this because countries and companies haven't got too long to get their act together on this. So which companies are affected by it? What is it you've got to do by June of 2026? What the requirements are as to how you select candidates, how people can challenge decisions that are made, what companies have to do to report what they're doing, how the penalty regime might work, and there's a special regime for member states that think that they meet the requirements already, and then a little bit on supporting bodies. So just a bit of background for those of you who may not have been following this as closely as some of us have done. The Commission originally had an idea of doing something in this area back in 2012, and they did put forward a directive at that stage. But the Council wasn't able to reach agreement. I think at that stage, enough of the member states thought that this was not something that should be dealt with by legislation. Instead, you should leave it to member states to use their own initiatives and see what they could achieve. But in 2022, it came back onto the agenda, and there was an agreed position for the Employment and Social Affairs Committee. And Parliament and the Council reached political agreement quite quickly, so that in December last year, the directive was actually published in the official journal. And member states have got until the 28th of December 2024 to adopt their national rules to implement this directive. And member states can adopt provisions which are more favourable to make sure that there's balanced representation of men and women for listed companies in their territory. So this is not a maximum harmonising directive. You have to tell the Commission what the laws are that you've adopted. This is going to affect listed companies, and it's listed companies who've got their registered office in a member state and whose shares are traded on an EU-regulated market, but not SMEs. And for this purpose, the definition of SMEs is a company that has less than 250 people and an annual turnover of 50 million euros or less, or an annual balance sheet of 43 million euros or less. And for any countries that don't use the euro, you have to use whatever the equivalent amount is in your currency. And the way it's going to work is that you look at where the listed company has got its registered office. So if you're incorporated in France, then you will be regulated by the French competent authority. So that's, I think, pretty much what you would expect. So what is it that you have to do? Well, the important thing to notice is you haven't got long. You've only got until the 30th of June 2026. And there's a choice as to what it is the company has to do. Either you have to say the requirement is that 40% of your non-executive director positions have to be filled by the underrepresented sex, and that's normally women. And if you go down that route, then there's a second requirement that you have to impose, which is that then the company has to itself set an individual quantitative objective for the executive directors to improve gender balance there. And the company also has to aim to achieve that 40%, the particular individual quantitative objective that it's set. The alternative to having that two-step approach is to say that the objective is 33% of all director positions. So that is both executive directors and non-executive directors. So it's slightly lower if you go down that route. And if you look at the directive itself, it's got a helpful annex at the back of it where you can look at the number of directors that there are on the board and what that means in terms of the number of people that you have to have from the underrepresented sex. Now, if as a listed company you haven't managed to meet the objective by the 2026 deadline, there is then an additional obligation that will apply to you. And this is to do with the way that you select your candidates to be appointed or elected as a director in the future. And you're required to adjust the process that you use for selecting your candidates for appointment or election. And there has to be a comparative assessment of the various candidates that you're looking at. And you have to have criteria that are clear, neutrally formulated, and unambiguous. And then you must apply those criteria in a non-discriminatory manner in your selection process. And the director tells you that selection process covers the notice of the vacancy that you prepare to begin with, your pre-selection phase, the way you shortlist people, and if you have selection pools of candidates, the way that you put those together. And all these criteria have to be agreed on before the process starts. And that's obviously to make sure that you've got a fair process that you will follow. What then happens is that if you end up with two candidates who are equally qualified, you must give priority to the candidate who comes from the underrepresented sex, normally women. There are some limited exceptions where you're allowed to depart from that. These are expected to apply only in exceptional cases. And in those exceptional cases, you would be arguing that because there's greater legal weight for those exceptional circumstances, that tilts the balance in favor of some other candidate. That might, for example, be because you're trying to be more diverse on racial grounds instead. But you still have, if you're going to do that, you still have to be able to show that you're making an objective assessment and you're taking into account the specific situation of a candidate from the other sex, and that you're doing it on non-discriminatory criteria. So you have to be, I think, very sure of your ground if you're going to go down that route and have very good, well-documented processes in place. The other thing that companies will have to do is, if it's shareholders who are going to be voting on a candidate who's being put forward, or if it's employees who are voting for an employee-elected candidate, they have to be properly informed of the requirements of the directive, and also of the fact that the company could suffer penalties if the requirements of the directive aren't met. I think partly to keep companies up to the mark on this sort of thing, there are also provisions under which candidates have the right to ask for information about the process that's been gone through. So if a candidate asks the company has to give the candidate information, firstly about what criteria they used as the basis for selection as far as qualification of the different people who were considered. They also have to provide information about the comparative assessment that the company did of the candidates. And if you're in one of those special exceptional circumstances where the company has decided that there are particular considerations that tilt the balance in favor of somebody else, you have to give information about that. If the unsuccessful candidate is able to show that they were equally qualified with the person who was chosen, what the directive says is that the burden of proof shifts, and it's for the company to show that they weren't in breach of the directive requirements. So, and member states are allowed to have evidential rules that are more favourable to the person bringing the claim that the company hasn't followed the right process. There will be lots more information available publicly about all of this as well. The first thing is that the companies will have to provide information every year to the competent authority for gender representation. They'll have to give information about how many executive directors and non-executive directors they have of each sex, and what measures they've taken to try and meet the targets. If they haven't met the targets, they have to explain why they haven't done that, and they then have to give a comprehensive explanation of what they've done so far and what they're planning to do in the future. And this information has to go onto the company's website as well, and has to be easily get-atable, so anyone who's got an interest in it can find it easily. And they also have to include it in their corporate governance statement that goes into their annual report every year. And in addition to that, each member state is required to keep a central list of listed companies that have met the objectives. And that has to be published and regularly updated. In order to make sure that this does actually happen, the directive provides for penalties and says that member states have to have rules on penalties, which, as usual, have to be effective, proportionate, and dissuasive. And there have to be adequate administrative or judicial procedures so that the obligations on the companies can be enforced. And you have a choice as to how you do that. It could be fines, but it could be, which I know some member states have adopted already, the ability to annul a decision to select a director where they haven't followed the right procedures, or to declare somebody's appointment null and void. And every member state will have to tell the Commission by December 2024 what those penalties are, and if they change them at any time, tell them what the changes are. Now, obviously, there's quite a difference amongst the different member states in the EU as to what they have done already. And so the directive tries to recognise this, the relevant provisions, Article 12. And for this, you need to know what the position of a particular member state was at the 27th of December last year. And either you have to be able to show that in your member state, the underrepresented sex held at least 30% of the non-executive directorships for listed companies, or 25% of all directors. And you can see that's all listed companies, and there's no exclusion for SMEs for this purpose. Or the alternative that you can show is if you can show that your national law in December 2022 required companies to meet these requirements of 30% for non-executive directors or 25% of all directors, and you've got enforcement measures in place where companies weren't complying with that, and that any listed companies that were not covered by the law were required to set individual quantitative objectives for all director positions. If you can show that you met these requirements last December, then the directive applies to you in a slightly different way, because what you're allowed to do is to suspend the process requirements to do with selection of candidates and the right for candidates who haven't been successful to get information, and also the requirement for the company to set its own quantitative objective for the executive directors, and the requirements for reporting. On reporting, your national law has to require the companies to provide information to an authority and give explanations if they're not meeting their objectives. So that one way or another, for all member states, there will be information available as to how listed companies are doing, and whether we are moving towards more balanced representation of women and men on boards. If you are a country that did meet these requirements back in December, but for some reason, at some future date, you no longer meet these conditions, then you fall back into the directive requirements and you get 6 months in which to apply those. It seems maybe a bit unlikely that that would be the case, but if it were, you would then have to meet the directive requirements. Every member state has to designate a competent authority, and the responsibility of that competent authority will be to promote gender balance on boards, to analyse what's happening, to monitor what's happening, and to support what's happening. There isn't more detail in the directive as to exactly what that means. So you have quite a lot of flexibility on that as to what you might do. I think there are some pretty good examples in some member states already as to what you might do. And certainly the directive envisages member states already have authorities designated it for equality purposes. And if you want to use your existing equality body to perform this role, then that's one possibility. I thought it would be helpful to try and give you some information about where we are in the EU at the moment. My slide comes with a bit of a word of warning because it was very hard to find information. And when I did find information, depending on the sources that you looked at, they slightly differed from each other. So having given you that health warning, I still think these are probably close enough to what's going on in order to give you a feel for where we are. The European Institute for Gender Equality is probably one of the best sources of information if you're looking for help on this. And according to my slide, it was 31.5% of board members of listed companies who were women, although there was a new report that came out from the EIGE, I think it was Tuesday of this week, and they seem to have a figure of 32.2% of the large publicly listed companies, so slightly higher. I know that there is already legislation in different member states, and again, it was quite hard to get definitive information about exactly what this is, and so if anyone in the audience knows I've got this wrong, I apologise, and please do put me right and tell me where I've gone wrong. But my understanding is that there is already legislative action in both France and Italy where they have a 40% target. In Belgium, the Netherlands and Portugal, where it's 33%, 30% for Denmark and Austria, and 25% for Greece. And I understand that there are already EEA states which are already above the 40% mark, and you can see those on the slide, and some member states that are above the 30% mark. Another bit of information that might be useful for you is that ECODA, which is the Association for Directors across the EU, they put out something, I think it was yesterday on International Women's Day. They said that 80.7% of the Stocks Europe 600 companies have at least 33.3% of women on their boards, and more than half of those companies have more than 40% on their boards. Interestingly, one of the things that ECODA picked out was that the percentage for directors who are chairs of companies who are women is much, much lower. So that's only 11.2%. If you look at the top executives in companies, they said that that's only 24.3% are women. And if you look at executive leadership teams as a whole, it's only 18%. And that if you look at the Stocks Europe 600 companies and look at CEOs, it's only 7.7% who are women. So you can see that although progress is being made at the board level, if you then look at CEO level and the senior leadership teams, there's a long way to go. It's interesting when you think about how this has worked in countries so far. For example, I remember in the UK, we started in 2012. In the UK, we don't have legislation. It's all been done without legislation. And somewhat to my surprise, we have moved from a situation where I think it was under 12% of boards for listed companies were women in 2012, to a situation where for the top 350 listed companies, it's now over 40%. And that was all done without legislation. So in an ideal world, in years to come, we won't need to have a directive because all listed companies that fall within the scope of the directive will have made an enormous transformation. And so the directive recognizes that and plans for its own demise if we manage to sort things out by 2038. And as part of that review process, there are a number of elements to that. The first is that member states have to report to the Commission about the measures that they have taken to implement the directive. They also have to report on what information has been reported to them, and also information about those individual quantitative objectives that companies are setting for their executive directors. And they have to do that by December 2025. So that's only a year after the directive comes into force. And then a year later, the Commission is supposed to report on what the situation is for those member states which were able to satisfy the conditions by December last year, and so aren't subject to the full requirements of the directive, and to see how that is going and whether they are also continuing to make progress or not. And then by 2030, there's going to be a report to both Parliament and Council by the Commission to look more broadly at what differences are being made. I suppose what I think is noticeable is if you look at individual member states, although there are some member states who are doing very well on this, there are other member states who are probably in the position that the UK was in back in 2012. And so they have an enormously long journey to make to do this. And I think the more help that those member states or companies that have gone through this process can give to companies and member states who do have a long way to travel, the more likely it is that we are to see progress. Now, you might notice on my slides that despite the heading at the beginning, I haven't said anything about management. And there's a reason for that, which is that the directive itself doesn't say anything about the management rather than purely about the board. That's maybe a bit untrue because in recital 26 it says, it's important that each listed company develop a gender equality policy in order to achieve a more balanced gender representation at all levels. Such policies might include the nomination of both a female candidate and a male candidate for key positions, mentoring schemes, and career development guidance for women, not for men, I notice, and human resources strategies designed to encourage diverse recruitment. So maybe as part of the journey that we're on, if we manage to make changes at the board level, then we might also start to think about what changes do we need at the management level too, so that we have a good pipeline of women coming up through the executive side of things who can be encouraged to take on roles as directors at other companies, as well as progress to executive director roles within their own organizations. Now, I find this topic a particularly interesting one. I think there is a risk that it could come into one of the areas of box ticking, at least to begin with, particularly if you're faced with what seems to be a very large change to make and not much time and resources to make it. It seems to me, though, that if we're really to reap the benefits of doing this well, what we need to do is to change people's hearts and minds about it. That takes more than just legislation, which is where sharing experiences and resources is particularly important. I'm going to stop there because I want to leave time for questions and thoughts as to whether this will be a problem in your member state, whether your member state has got it all sorted. I did try and find out whether there was yet published a list of those member states that think that they meet the criteria as at December last year, but I wasn't able to find that. So again, if anyone has been able to find that information or can say categorically that their member state does already meet the criteria, that would be interesting to know too.